Good afternoon. I'd like to call this meeting of the Civil Subcommittee of Courts of Justice to order. Members will indicate their presence on the electronic voting board. The clerk will close the roll. Quorum is present, so we're ready to begin. Delegate Kent, I see that you are here, and we've got a bill that went by for the day last week to address some concerns that I think Delegate Keys-Gamarra had addressed. In the meantime, I understand that a very similar version of your bill, or something that was your Senate cognate, I guess, passed the Senate Courts of Justice Committee. And so I've had counsel prepare a bill that would conform your bill to what came out of the Senate. I don't want to defer to them too much. So the other thing I would propose we do is we adopt that substitute that I also asked that we put a reenactment clause on the bottom of it, just to make sure that the bills get to conference. So if we make any changes, we'll have an opportunity. If everything looks fine when it comes over and everything's addressed, then you can have them, the Senate will take off the reenactment clause, we'll accept their amendment, and that'll be the end of it. But if there's still some things to be worked out, we can throw the bills into conference and we can work on them together. Does that sound like a good resolution?
That sounds great. Thank you, Mr. Chairman.
All right, so get a motion on the substitute?
So moved.
All right, it's been moved and properly seconded that we adopt the committee substitute. As many as favor of that motion will say aye. Aye. Those opposed? All right, then can I get a motion that we add a line amendment adding or amendment to the substitute adding a reenactment clause? Oh, it's already on there? Having spoken with the delegate, I want to give up
There it is again. There it is.
All right, and then so you have a substitute, which I guess what it does is it conforms it to what the Senate did and adds the reenactment clause.
Perfect. Yes,
all right.
Sir.
Is there a motion to report as amended with substitute?
Report as amended with substitute.
All right, been moved and properly seconded. Clerk will open the roll. The clerk will close the roll. Bill reports by a vote of 5-0.
Thank you so much.
Delegate Kent. Thank you for your work on this. Appreciate it.
Me to come back. Thanks.
All right, Delegate Arnold, you've got two bills before us. All right, why don't you come forward and present your first one, whichever one you want to do first. You tell us.
Thank you, Mr. Chairman, members of the subcommittee. I'd like to take up 1846, if I may.
All right, 1846 from Delegate Arnold. This has to do with the Crimes Against Minors Registry.
That's correct, Mr. Chairman. Mr. Chairman, members of the subcommittee, what this bill seeks to do is require Commonwealth's attorneys who are given notice of the name change by someone that's required to register on the Sex Offender and Crimes Against Minor Registry to notify the victims of the proposed name change. It also allows for the victims of these crimes to appear personally or by counsel or to submit a written notice to the court. Under current law, a person required to register petition for a name change could only be granted if the court finds good cause within the petition itself, and upon the finding of that good cause, then the court is required to notify the Commonwealth attorney, and this would require that Commonwealth attorney to use reasonable efforts to locate the victims to see if they are interested in having their voices heard in the process.
All right, any questions from members of the subcommittee for Delegate Arnold? So Delegate Arnold, I guess, is there a problem we're trying to solve? Is there a case that's happened somewhere? Because it seems to me that we already make, there's a process in place, as you've identified in your presentation, right, to prevent people from using the name change process to try and evade or game the system, right, and keep their name from showing up on the sex offender registry. There is opportunities on the sex offender registry now. There's an alias line, so people have to register under their current name and any previous names. They have to register their aliases as well and all that to stay compliant with the registry. So do we have a case of someone who felt like they were deprived some sort of due process by not having this kind of notification from a Commonwealth's attorney? I'm just trying to figure out what the history might here be. What am I missing?
Mr. Chairman, members of the committee, I don't know of a specific case to cite to. I think what this bill is trying to do, and its intent is to make sure that the people that have been the victims of such crimes are aware and know what's going on, as opposed to having to respond to after the fact, after the petition has been filed or granted by the court. What this does is limits re-victimization, in my opinion, and I think that's the intent of the bill.
Thank you. Any other questions for the patron? Anyone in the audience wishing to speak in favor of the bill? Anyone in the audience wishing to speak in opposition to the bill? Come forward.
Good afternoon, Mr. Chairman, members of the committee. My name is David Smith, and I am wearing my Safer Virginia hat today. Safer Virginia is an organization that is working with people who are on the registry and trying to ensure that we have less people that end up on the registry and those that are able to reintegrate into society successfully. We are concerned about this bill because it seems to add another layer of what that means for folks that are required to register. I can think of one instance specifically where this bill could have caused trouble for a person on the registry that I know. She had made some mistakes and in a bad spot ended up with a conviction dealing with sexual relations with a minor. And 3 years later, life was better. She got married and she changed her name. Under the way this bill is written, that minor, who would now have been about 20, 22 years old, would be able to try to stop her from changing her name. We feel like that is a large overstep of what should be happening in this space. And in regards to the notification side of things, there is already a way to receive notification if you want on the website itself, on the sex offender website. So by having the Commonwealth's attorneys going out and trying to find people, that could actually re-victimize folks who have moved beyond or don't want to deal with that part of their past anymore. So we respectfully ask you to vote no on this.
Thank you. Anyone else wishing to speak in favor or against? Oh,
Mr. Chairman, Robert Tracy with the Attorney General's office. We support this bill because, as has been
if you
discussed.
go ahead and step to the mic and reintroduce yourself. There are
sir.
folks that are following along at home. We heard you, but the folks following along.
Robert Tracy with the Attorney General's office. We support this bill because, as has been testified to, this bill is victim-oriented common sense. It gives victims an opportunity to be heard before someone who's on the sex offender registry attempts to change their name. And these are not ordinary offenses. These are offenses like forcible sodomy, rape, kidnapping a minor for prostitution, aggravated sexual battery, indecent liberties of the child, object sexual penetration. Good cause is the standard that the code requires now for someone on this registry to change his or her name. Good cause is not defined, and people of good conscience could disagree about what good cause means, including the Commonwealth's attorney and the circuit court judge. This common sense proposal gives victims a voice in the process. It's not conclusive, it's not dispositive, it merely says a victim of a crime for which someone is on the registry should be heard in the process and have the dignity of his or her voice received by a circuit court. For that reason, we'd ask you to support the bill.
So I would ask, Mr. if you, with your indulgence here, can you answer the question I asked Delegate Arnold? Do you have a case in mind? Is there a specific victim that's come to you and said that somebody changed their mind, their name, and they felt wronged by their inability to participate in the process?
An individual case, most Commonwealth's attorneys will reach out already and talk to victims, but it doesn't mean it happens in all cases. This intends to create a uniform standard, a common sense standard that places a victim of these offenses in a position for their voice to be heard. I was a Commonwealth's attorney, and the practice was to inform victims when this was occurring for their voice to be heard. This merely codifies common sense dignity for victims of these offenses.
All right, thank you.
Thank you.
Thank you.
All right. Any further information? Any questions from any? Oh, Delegate Ballard.
Thank you, Mr. Chairman. So maybe for the last speaker from the Attorney General's office. So I'm reading the bill, and we talk about that good cause standard that you just mentioned. Delegate Arnold's bill doesn't do anything with that standard. It doesn't define it. What I'm reading is it just says that there should be reasonable efforts made to contact the victim so the victim, if he or she so chooses, can show up and speak his piece or her piece.
Exactly right.
That's all it is, right?
That's exactly right, Your Honor.
Okay, thank you.
All right. Thank you. Any last word, Delegate Arnold?
I just asked the committee to support the legislation.
All right. Committee operates by motion.
Move report.
Second.
It's moved and seconded the bill report. Any substitute motions? All right, clerk will open the roll. All right, the bill reports by a vote of 6 to me. That's fine.
Thank you, Mr. Chairman.
All right, Delegate Arnold, you got another one, House Bill 1854.
Yes, Mr. Chairman, members of the subcommittee. There's a substitute with this, Mr. Chairman.
Yeah, is there a motion on the substitute?
Move the substitute.
All right, it's been moved and seconded that we adopt the committee substitutes. May favor that motion will say aye. Aye. Those opposed? All right, the motion carries. Delegate Arnold.
Thank you, Mr.
Substitute
Chairman.
now before us.
Thank you, Mr. Chairman. Members of the subcommittee, what 1854 is attempting to do is to give standing to certain individuals whose rights have been terminated, and subsequent to that termination, it offers them the opportunity to have standing to bring a petition for custody and visitation under a very narrow set of circumstances. Currently, and it does so by amending the definition of a person with a legitimate interest. Currently, any person or any parent whose rights have been terminated, or any person claiming through the parent's rights have been terminated, is ineligible and is technically not a person with a legitimate interest as defined in the code. What this bill does is set out a very narrow circumstance to where these individuals would have standing to get back in front of a judge for a petition for custody. The specific case that brought this bill to my attention was a case of a child that had been adopted when he was 2 years old. His mother's rights were voluntarily terminated. She signed a post-adoption contract agreement. She adhered to the post-adoption contract agreement throughout the life of the child. When the child hit the age of 16, both adoptive parents passed away, and there was no one to care for the child, and so the child is currently in foster care. The Commonwealth of Virginia, we rank in the top 10 with the least amount of children in foster care. We also rank in the top 10 of the amount of legal orphans that are currently in the Commonwealth. The last data I saw, which I believe was for the year 2023, had that number at 1,900 legal orphans. So this bill would basically say if the child's 14 years of age or older, he's had a permanency goal previously achieved by adoption, has had his adoptive parents die or pursuant, or each child's adoptive parent has permanently been relieved of custody, and each adoptive parent has parental rights terminated, and provided that the parents whose rights had previously terminated complied with the terms of a post-adoption contract, a communication agreement, and maintained a positive continuous relationship with the child since termination, could come to court and file a petition and be heard by a judge of a JDR court or other court of competent jurisdiction to determine whether or not custody transfer would be appropriate. I welcome any questions the committee may have.
Thank you, Mr. Chairman. Question for the patron regarding, and this is just a truly fact-finding question, only because we don't have color printouts. Can you go through what the substitute changed and the purpose for those changes?
Mr. Chairman,
Because I can't see them.
Mr. Chairman, I would answer the delegate when initially drafted, this bill attempted to rectify or the mechanism it tried to go through was 16.1-283, which was the termination of parental rights statute. Upon meeting with stakeholders, it seemed as though that mechanism may result in unintended consequences, such as the sealed adoption records of the child, and cause some issues that way. In speaking with stakeholders, my intent was just to try to give this a parent that would meet this narrow circumstances standing to come to court. Currently, they're a legal stranger to the child. They have any petition they filed will be summarily dismissed by the court for lack of standing. This doesn't guarantee that the child would be placed back with the biological parent. It just guarantees that if they can prove these circumstances and get standing, then the court would have to accept the petition. The child would still be represented by a guardian ad litem, and if the child is in foster care, which the bill includes in its contemplation, the Department of Social Services and would be represented by counsel and could argue for or against the granting of the petition. Does that answer the delegate's question?
It does, Mr. Chairman.
Thank you, Mr. Chair. Just, I think I'm reading the words on the page. I think they're clear enough, but Delegate, the last words, I guess each of these paragraphs is more or less the same, isn't it?
That's my understanding, Mr.
So the second requirement, maintained a positive continuous relationship with the child since termination. Is that new from your original? Is that part of the substitute?
No, it was in the original introduced.
So just so I'm clear, so that means that a parent gave a kid up for adoption or lost parental rights at age 2 and has not spoken a word or communicated with or have any relationship with the child when he or she then loses her adoptive parents. That parent would not satisfy these criteria, would not be covered by this exception. Isn't that
That's correct. I'm sorry, Mr. Chairman, I would answer the delegate by saying that's correct.
Thank you. Delegate Kilgore.
Yeah, so basically, Delegate Arnold, what you're saying here is once the adoptive parents, either they lose custody, they pass away, or I forgot the other one. There was three options there. Once all that happens and they're completely out of the way, then this parent, natural parent, could come in and file.
Mr. Chairman, I would answer the delegate, that's correct.
Okay, thank you.
All right, thank you. Thank you. All right, is there anyone in the audience wishing to speak in favor of the bill? Please come forward.
Good afternoon, Mr. Chair. Valerie LaRue from Virginia Poverty Law Center. And we very much are in support of what Delegate Arnold is trying to do with this bill. The one concern we have is the one that was raised by Delegate Sullivan, and that is that many parents, even if they have the post-adoption contact and communication agreement with the foster parents, it's not within their control whether they have this positive relationship with their child because their rights are terminated. Even if they have that PACA, sometimes the foster parents or the adoptive parents don't honor it. So I hate to put a restriction on this person applying for custody now that they had no ability to, to do anything about. So it's outside of their power. I certainly think that in the negative, like if they had the opportunity and didn't take it or didn't act on it, that would be one thing. But here we're just cutting them off over something that they have no control over. So that's my only concern with the bill. Otherwise, we support it. Thank you.
All right, thank you. Anyone else wishing to speak in favor of the bill? Anyone in opposition? All right. I understand the Poverty Law Center's concern. I think I kind of like it the way it is, and we'll see how it works. And if we find that it doesn't do the job that it's trying to do, maybe we come back and see if that particular element is cutting too many people out of the process. This one doesn't sound like it's awfully specific to be just generic. There's a story behind this one, Delegate Arnold?
Yes, that's actually the facts of a case that was brought to my attention. And I would tell the committee, Mr. Chairman, that the biological mother tried to intervene in the process when she learned about this. And my understanding was that the juvenile was appeared by video and was having a very hard time understanding why he was having to stay in foster care. It seems as though this mother really rectified her life, and although the Poverty Law Center is correct, sometimes these PACAs are not under the control of the petitioning parent in this case. They do have a mechanism under current law to go to the circuit court and enforce those post-adoption contract agreements.
All right. All right, I think we're ready for a motion. It's been moved and properly seconded that we report with substitute. Clerk will open the roll. Members can cast their votes. Clerk will close the roll. 7-0.
I thank the chairman and members of the subcommittee.
All right, Delegate Munden King, Chairman Munden King. You've got two bills.
Yes, thank you so much. Can we take up 2362 first, Mr.
We
Chair?
can. Let's take up House Bill 2362. Delegate Munden King.
Thank you. So House Bill 2362 is a bill that will revise procedures governing the sale of real estate to satisfy unpaid real estate taxes. It provides additional protection for parties who may have an interest in the real estate, and it is recommended by the Boyd Graves Commission as well as the Virginia local government attorneys.
All right, you guys heard who recommended this bill? Any questions from members of the subcommittee? Anyone? All right, it's moved and seconded to the bill report. The clerk will open the roll. Clerk will close the roll. Bill report 7-0. Delegate Munden King, you're on a roll.
Thank you. Next
I
up.
see some looming bodies on the next bill, so I don't know. We'll see if it goes as smoothly.
Well, now I know what to say first. This is a Boyd Graves Commission. Now, I'm new here in this committee, but now I get it.
Great study.
Great study. Thank you so much. So this is another Boyd Graves recommendation that will address the statute of limitations for wrongful death suits. So what it does is it creates a tolling while a situation is being resolved. The problem is there's a current misalignment in the suspension of statutes of limitations between personal injury and wrongful death cases. If a person is injured, the statute of limitations for a lawsuit is tolled while any related criminal proceedings play out.
So, Delegate Mundy, if I understand this correctly, so if somebody hits me in the side of the head with a tire iron and I've got a, damage and, severe loss of capacity and so forth, my claim for that is told, my civil claim against him for all the damages he's done to me or her, she's done to me, is told while the assault and battery case is tried and we go through it, they go through their appeals and everything. But if they hit me hard enough with the tire and iron that I actually die, then we don't get the benefit of that extended tolling period. And so they're rewarded for hitting me harder by not getting, by having the case have to be brought in a shorter period of time. You might not put it that way, but I understand.
I would not use that example, but I think you have it correct.
All right. I know we've got some folks chomping at the bit to disagree with that assessment. So anyone else on the subcommittee have questions for Delegate Mundy King? All right. Anybody here wishing to speak in support of this Boyd Graves bill?
Mr. Chair, members of the committee, Eric Link speaking on behalf of the Virginia Bar Association. We support the bill.
All right. Delegate Love, was you going to get your question in to Mr.
I was
Link?
just wondering if anybody in the audience had a tire iron. I'd like to see this play out.
I didn't mean to give anyone any ideas with my example. All right. And I think we have some folks wishing to speak in opposition to the bill. Please come forward.
Mr. Chairman, members of the subcommittee, Scott Johnson, General Counsel for the Medical Society of Virginia. We chatted briefly with the patron and would like, if this will of the committee for this bill to go forward, we would like to look at some language because candidly we want to make sure we don't have an open-ended situation where you've got a criminal prosecution and 5 years worth of appeals and things of that nature. So we're just trying to look for some parameters or definition as we go forward. And so we told her we'd be glad to work with her and appreciate her hospitality on that.
Okay. Last question.
Delegate Sullivan.
So, sir, Ms. Johnson, I don't want to get involved in your negotiations, but are your concerns that you're looking to address related only to the wrongful death portion of it, or do you have the same concerns with the tolling of the personal action for damages? They'd be the same, wouldn't they?
Sir, Mr. Chairman, Delegate Sullivan, they'd be the same. Yes, sir.
Okay.
Anytime anybody writes insurance, they want to know clear parameters, goalposts, timeframes, and so we just see if we can find some language that will do that. We don't mean any harm to the underlying purpose of the bill, just want to tighten it up.
Okay. Thank you, Mr.
All right. Anybody else wishing to speak in opposition to the bill? Well, this is a long process. This is the first step in it, and I'm sure there'll be other opportunities if somebody has some good ideas. I always, we're trying to fix one thing, and then we end up maybe making the whole situation less beneficial for consumers or different. But that said, if Delegate Mundy King is inclined to continue to work with you, I hope you guys will continue to do that. And, something comes up between now and full, or, I don't get to the floor as it goes over to the Senate, I'm sure there'll be lots of opportunities to fine tune things. So with that, the committee operates by motion.
Move the report. Second.
It's been moved and seconded the bill report. The clerk will open the roll. Clerk will close the roll. Bill report 7-0. Thank you, Delegate Mundy.
Thank you so much, Mr. Chair.
Delegate Cole, you're here, so you're next.
Thank you, Mr. Chair, members of the committee. I would ask if you would bear with me because I have a little bit of explaining to do on the bill. So, Mr. Chair,
that's explaining. No,
yes, explaining to do. I have HB 1733, which is before you. It's a bill to improve the relief of custody process here in our Commonwealth. The bill came out of the Commission on Youth Study, and in conducting the study, the Commission held 4 regional roundtables and an advisory group meeting of stakeholders. Judges, legislators, members of the executive branch, and representatives from social services, mental health, and school professionals vetted recommendations made by the Commission. This bill makes an amendment to Code 16.1-277.02 to ensure better support for families and higher standards in court proceedings. The way this improves the court process is by one, the bill standardizes investigations found in lines 18 through 19. Local departments of social services will now provide a written report for each petition, ensuring consistency and thoroughness in investigations. The written report will be provided and used by judges when hearing these petitions. In order to ensure that all localities are able to comply with this recommendation, the bill includes an enactment clause for the Department of Social Services to work with localities in creating a template for the written report. Secondly, this bill states and clarifies in lines 15 through 22 that families petitioning for relief of custody will get access to an evaluation for the need for services for their children. Families will be referred to the Family Assessment and Planning Team, where FAPT will determine eligibility for Children's Services Act, the CSA, and make service recommendations to families and hopefully keep the child out of foster care. Third, this bill increases the court's standard of proof when hearing the petition in lines 48 through 49. And finally, the bill in the third enactment clause directs the Office of the Children's Ombudsman to establish a work group to work with judges and other stakeholders on evaluating good cause shown in relief of custody cases, and if the amendment is adopted, to look at the standard of evidence. I do have a representation here from counsel from the Commission on Youth, if you all have any questions as we move through this piece of legislation.
So, yeah, thank you, Delegate Cole. And one quick observation. I think that, and they came by my office, the folks from the Commission for Youth, and I appreciate them coming by and chatting with me about this earlier. And I think as a result of that conversation, one of the things you talked about, which is the raising of the standard of evidence, that's been moved out of the body of the bill and into the work group to look at. Because the way, as I sort of saw what was happening here, was we're going to raise the standard of proof, make it more difficult, but we're also going to supply litigants with a checklist of things that they needed to do to achieve that. And it seemed like you couldn't raise the standard without that. I just thought it was a little bit out of order. I think they agreed with me that we'd have the work group look at both those issues so that whatever legislative change makes those things happen at the same time. Does that make sense?
Yes, sir.
And so the other thing I noticed, and I think it's a friendly amendment, but the bill requires people to start using a standardized form, but there's also a work group that has to develop the form, and so none of that goes into effect till July 1st. So I think we need probably a delayed enactment till January 1st of 2026. So not a lengthy one, but in other words, the form is not going to exist for them to start using until the work group finishes its work, which is slated to be done in November. So friendly amendment to then have a fourth enactment that says that the first enactment is delayed effectiveness until January 1st, 2026. Can I get a motion on that?
I second the amendment to the substitute.
Yeah.
We have to adopt the substitute too.
All right, let's move let's move the substitute.
So moved.
All right, it's moving to second. We adopt the substitute. Those in favor of that motion will say aye. Aye. All right, now I renew my motion that we amend it to add a reenactment that's been seconded. So those in favor of that motion will say aye. Aye. Those opposed? All right, so we now have a substitute with a reenactment, or not reenactment, excuse me, a delayed enactment for the first enactment until January 2026. Now, with that, Delegate Ballard, do you still have a question?
Oh, thank you, Mr. Chair. No, I think you answered it. I was going to ask the question about the preponderance of the evidence going to clear and convincing, but it sounds like, Mr. Chairman, you addressed that, so that was my concern.
All right. Any other questions from members of the subcommittee? Anybody in the audience wishing to speak in favor of the bill?
Mr. Chair, members of the subcommittee, James Pickrell with the Virginia League of Social Services Executives, and we support the bill.
All right, thank you. All right, anybody here wishing to speak in opposition to the bill? All right, seeing none.
Move the report. Second.
So moving second to the bill report with substitute as amended.
Second.
It's properly seconded. The clerk will open the roll. Clerk will close the Delegate Leftwich. You have a vote? The clerk will close the roll. Bill report 7-0.
I thank the chair, members of the committee. Thank you.
Excellent explanation. All right. I think we are left with some member bills. Do we have any non-member bills that we just haven't gotten to? Delaney, when she comes over. Let's do this. I would entertain a motion from somebody to take House Bill 1864 from Delegate Hernandez and House Bill 1882 from Delegate Sewell by for the day.
So moved.
It's been moved and seconded that House Bill 1864 and 1882 go by for the day. As many as favor of that motion will say aye. Those opposed? All right, I talked to both those patrons in advance and told them we would take their bills by so they could work with stakeholders. The clerk's not here, is he? Okay. All right, if we could do a little notice to the non-patrons to come on over the whatever we do to text them or whatever. And in the meantime, we've got some bills from committee members that we can go ahead and take up. Delegate Reeser, your House Bill 1913. We took that by for the day last week. Did you make any progress on that, or did they give up?
Thank you, Mr. Chair. I think there's been some conversations had, but no resolution, so I'm prepared to go forward and they can work with it on the Senate side.
All right, so tell us again what House Bill 1913 does.
Sure. Thank you, Mr. Chairman. This bill comes to us as a recommendation of the Virginia Bar Association's Real Estate and Land Use section and has been vetted with the Virginia Court Clerks Association. Clerks in various jurisdictions currently, and sometimes deputies even within the same clerk's office, are charging filings in ways that are not consistent and charging filing fees sometimes in ways that are unpredictable. This means that attorneys and settlement agents sometimes plan for and collect fees to pay for a single recording, but then they're surprised with multiple recordings when they show up. Or conversely, the parties plan for multiple recordings and must return money to clients or donate money to the clerk's office because it's being handled as a single recording. And the unpredictability is costly and increases risks of mistakes being made. So this bill will bring uniformity to the recording and fees for various filings, which are primarily commercial, such as deeds of trust, quitclaim deeds, and UCC filings. And it will put into code the approach that most clerks currently do take. It also clarifies that no recordation tax is required when a quitclaim deed is used to pass property from one person to another without any compensation. And finally, the bill specifies that a single document should be treated as a single document for the purpose of calculating fees, even if the document serves more than one purpose.
Thank you, Delegate Reeser. Any questions from any members of the subcommittee on this fine bill? All right, anyone wishing to speak in favor of the bill?
Mr. Chairman, members of the subcommittee, Eric Link on behalf of the Virginia Bar Association. Delegate Reeser did a very nice job summarizing the bill. We do have Sean Lundy from the VBA's real estate section on the line if you guys have any substantive questions, because heaven knows I am not prepared to answer them for you.
Mr. Link, I actually do have a substantive question. Again, as much as I love this bill, I guess the question is, how much harm would you all say it would do to the bill if we were to, on line 65, strike out the language that says including a record of a mortgage as a financing statement pursuant to 8.98502. In other words, I like what you guys are doing, which is saying you can't charge more than one fee. I always get a little nervous. And I know we've got including, and so we know including means but not limited to. I know this was the real focus of the group, the folks that brought it to you. So if they say, no, we really want to keep it, I'm not going to get in the way. But I do, the one thing that makes me a little nervous, and I'd love to get some feedback about it, is, do you think that if we took that out, that their situation would still be covered? Or they really feel strongly they need this language in there to cover their particular problem?
Mr. Chair, this is where I would defer to Mr. Lundy if he is available to testify virtually.
All right, is he online?
He should be.
Oh, he's raising his hand.
Yeah.
I see the little icon. I'm waving back.
You gotta push that on, Sean.
Here he comes.
He doesn't go by Michael.
Good by Sean.
Does that mean he's using his?
Can you hear me? Can you see me?
There you are. Did you hear my question, Mr. Lundy?
Mr. Chair, yes, I did, sir. And I read on my other screen the language, and I actually think your suggestion would be probably a better draft than what we proposed for what we're trying to accomplish.
Flattery will get you anywhere. Yeah.
By the way, for those of you taking notes at home, this is a perfect testimony.
Yeah, perfect.
If you're teaching advocacy classes. So I would entertain a motion to, on line 65, starting with the word including, strike from including through 502, comma. You got it?
So moved. Second.
It's been moved and properly seconded. As many as favor that motion will say aye. Aye. Those opposed? All right. Thank you, Mr. Lundy, for your excellent testimony.
Thank you, Mr. Chair.
All right. All right. Any other questions? Anybody wishing to speak in opposition to the bill? I know that there's some folks that had some heartburn about it, but I guess they aren't here now.
Have it now after that testimony.
All right. Delegate Reeser, I think this is a great, well, I'm going to go on and on. I'll go on the floor about it, how wonderful it is, how much it helps things. So the motion to report, is there a second? Second. It's moved and seconded. The bill report as amended. The clerk will open the roll. The clerk will close the roll. House bill reports 7-0. We got a whole.
We don't have emojis.
We had a 6 to the left which bill last time. Delegate Clark, thank you for responding to our summons, our bat signal that we threw out there. Patrons come.
Oh, no worries.
Which bill do you have?
2174.
Okay.
Awesome. Good afternoon, Mr. Chair and members of the subcommittee. HB 2174 is a recommendation of the Boyd Grace Conference. It provides technical fixes to better reflect the General Assembly's intention back in 2017 in limiting the liability of third parties to claim malpractice by someone else's lawyer. It clarifies the statute of limitations and expressly limits claim to only the situation the General Assembly has deemed worthy, primarily situations in which the client and an attorney explicitly states in a written agreement that they intend to confer rights to claim malpractice by a third party. The bill deals with a rare situation in which a third party beneficiary, not a client, argues that it was harmed by legal malpractice. This is a very rare circumstance, and the General Assembly has already decided, generally speaking, that third parties cannot claim malpractice by someone else's lawyer. This simply contains technical fixes to ensure that the General Assembly wills plays out in this practice, and I urge the members of the body to support this bill.
All right, any questions from members of the subcommittee? Anyone here wishing to speak in favor of the bill?
Mr. Chair, members of the subcommittee, Eric Link on behalf of the VBA, we thank Delegate Clark for carrying the bill, and we support it.
All right. Anyone here wishing to speak in opposition to this Boyd Graves bill? All right. Seeing none, committee operates by motion.
Move to report.
Second.
Been moved and seconded the bill report. Clerk will open the roll. Clerk will close the roll. Bill report 7-0. Thank you, Delegate Clark.
Thank you, Mr. Chair.
All right. Yeah, Delegate Delaney will hopefully make it over.
Want me to go?
She knows she's up. Okay. All right. Delegate Sullivan.
Thank you, Mr. Chair. I'm going to tread on the committee's time just a little, give a little background on this bill, HB 1914, Mr. Chair. So some of you may know I've been working in this space for a number of years. This has to do with what we do with, in terms of compensating wrongfully convicted and imprisoned Virginians. It happens not often, but too often, that someone is sent to prison for a crime he or she didn't commit. And we have in the Commonwealth adopted a system for what we do when that person has a claim for compensation. Other states do it differently. We've spent some time over the last several years sort of comparing our process to other states. I think it's fair to say, at least so far, from what I can tell, this body is comfortable with the process we're using, but we have made some changes over the course of the last several years for some of the folks that may be new to the General Assembly. We've, for instance, changed the annual amount. The process is essentially how many years have you been in prison. You get compensated an amount per year, and there's some other things around the edges. We've increased that amount. We've made it go up annually based on CPI. There were some other fixes. It used to be that if you had pled guilty, you could not claim under this statute. We ignored that a few times and then finally took it out because we all know of the reasons that someone might plead guilty even though they're innocent. We also did away with a process that required that the payment be made over a period of time, basically in an annuity. And it was some sort of, in my view, sort of paternalistic notion that someone shouldn't be given their, whatever, the entirety of what they're entitled in one amount. I should add that this is always at the General Assembly's discretion. This legislation sort of provides our guardrails. But what it does do is it provides a measure of predictability to people. And importantly, keep this in mind, avoids litigation, which, as we all know, can be time-consuming and expensive. One thing that happened, this one was not my doing, but several years ago when the General Assembly was dealing with the Norfolk 4 situation, is we recognized here in the General Assembly and now in our code the difference between I'll call it an unintentional wrongful conviction and an intentional wrongful conviction. I won't go through the story of the Norfolk 4, but that clearly was an intentionally wrongful conviction because unfortunately, again, not often, but too often, there can be bad conduct. And the notion is, and it's in our code already, and I'll show you exactly where, that on those situations, under those circumstances, the compensation should be increased, multiplied as a matter of fact, not unlike what a lot of us in the civil world know, treble damages, or for that matter, punitive damages. So let me walk you through what HB 1914 does. The first thing on page 1, lines 26 and 27, last year I was before you and I actually had a claimant that I had a bill for who had been released, had never done the crime, of course. This only happens, was seeking compensation, but had been for several years, I want to say 6 or 7 years, on the sexual offender registry for those 6 or 7 years. And the notion, as you might all expect, I made this argument to you all last year, a lot of damage to one's life when you're trying to make it in the world. On the SOR, he couldn't go to his kid's school, things like that. So what we did was we added the words that are on lines 25 and 26 that you can get extra compensation if you've been on the sexual offender registry. Now, it can be interpreted, the way these words are written, to mean you get compensation under the statute for all the years you've been on the SOR, even those years when you were imprisoned. And candidly, I could make you the argument that some people have made the argument to me that being in prison as a convicted sexual offender is a different experience than being in prison for other offenses. But as I thought about this upcoming session, that is not how I pitched the bill last year. That is not what this committee, and in my view, the General Assembly intended when it passed the bill last year. As I say, if you look at the way it works, look, for instance, at lines 25, we do give extra money if you are wrongfully incarcerated and on death row, so that would be for the entire time you're in prison. But I'm trying to clarify what we did last year and do away with at least what I think is the wrongful interpretation of what we intended to do. And that's why this bill, 1914, adds the words after release from incarceration. I'll leave to others in the future to decide whether that is fair. But in the interest of candor and in terms of what we accomplished last year, I thought it important that we come back and fix what I think, at least make clear what I think we intended last year. So that's the first thing it does. The second change gets back to the point I was making earlier about intentional conduct by the Commonwealth. We already recognize, and if you look at paragraphs A and B of 195.13, we recognize that if the Commonwealth engages in wrongful conduct, fabricates evidence, withholds evidence, fabricates testimony, you'll see that what that does is it doubles the amount due under the initial statute. It then goes on in paragraph B to double that yet again. All right, paragraph B, as it's currently written, says that you get another doubling of it, except it conditions it explicitly. And you look at lines 65 through 66, but look at 66. These are currently in the code. I'm trying to take them out. It says that original doubling of it, so if you're getting $100, you get $200. It says any compensation awarded thereunder shall not become effective and payable until, and then go down to line 69, it says the political subdivision involved also decides to match that $200. So in the case of the Norfolk 4, they got 4 times what they were entitled to under the sort of, I'll call it the base number. That's because in that particular case, there'd been litigation with Norfolk and that sort of thing. And so that's how we wrote it. And we wrote it, I suggest to the members of the committee, in a way that made sense for that case, but it makes no sense for cases going forward. Because what it does is it makes localities, essentially, or gives localities a veto power over what we can do and what we, in my view, should do. What about a locality that either won't match it or of a locality that can't match it, can afford to match it? In those circumstances, we would be, under the current version of the code, unable to not only quadruple it, but not even able to double it in a situation in which clear evidence is out there of wrongful conduct on the part of law enforcement. So that would leave these Virginians only really one option, and that's to sue. And that's to sue. So that's why you'll see in paragraph, on line 59, I suggest we just acknowledge what we did several years ago for the Norfolk 4 and say under these circumstances, the legislature can, I hence hasten to note, it uses the word may, it doesn't say shall, may pay up to 4 times the base amount. Now, so if you're asking yourself, gee, Sullivan, how did you pick 4? I didn't pick 4. I would suggest to you that the General Assembly some years ago picked 4, and in my view, not unlike what I did last year, inartfully, or at least wrote the statute in a way that wasn't as forward-thinking as it should have been. We're all familiar. The code's full of situations in which, in the civil context, people can get treble damages. You can get treble damages under our VCPA if someone sells you bad drywall, right? So you can get it if someone sells you a watch and tells you it's from Switzerland and it's really from China or Brazil. You can get triple damages if someone mistreats you and selling you health club services. So again, my suggestion to the committee is that in a situation where we have deprived someone of their liberty, in many cases for years, the choice that we made a few years ago to quadruple them makes a lot of sense. I bring this year because I'll tell you, and these are not before you right now, they'll go straight to appropriations. I have 2 bills relating to men. These are men this time. One was wrongfully convicted and served over 20 years in prison. The other is a gentleman who, as far as we know, is the longest serving wrongfully convicted Virginian, and we think the second longest in the country. He served 45 years in prison, went in at age 20, and came out at age 65, his entire adult life. And that's why I picked this time to try to clarify this. And I'll have to be going in front of the Appropriations Committee to essentially make this same argument. But my guess is the plaintiff's lawyers up there would agree that a lawsuit, if we force someone to file a lawsuit who's been deprived of 45 years of his or her life, that's going to be a big number. Any jury's going to give that person a big number. So I ask you not to worry so much about the number here. This is obviously going to apply to someone who's been wrongfully in prison for a year, or would apply to someone who's going to be wrongfully in prison for much more than that. The issue here is the principle And frankly, as I said, the precedent, because we have already done this. So, Mr. Chair, thank you for the time, members of the committee, but I did think you ought to have heard the background about how Sullivan dreamed up this idea to quadruple the amount of money. As I said, it's already in our code, and I think I'm simply clarifying it and making the process work better.
Delegate Ballard.
Thank you, Mr. Chairman. First, Delegate Sullivan, thank you for last year. I think it was last year, maybe the year before, you carried a bill to help out one of my constituents, David Kingery.
Yes, that was Mr. Kingery, yes.
Mr. Kingery, who basically spent a year in jail and now I think 8 years on the sex offender registry for that wrongful conviction, and he was compensated by the General Assembly. I think he received his money actually this year. So my question to you, Delegate Sullivan, is this in any way retroactive to someone like Mr. Kingery's situation where he's already received some amount of money from the 1 year wrongful incarceration and then the time spent on the sex offender registry? Is he eligible, or people like him eligible to get more under this bill, or are they kind of barred at this point?
Well, okay, so now we're doing legal opinions. No. Well, Mr. Kingery has been compensated in the manner that I envisioned. In other words, Mr. Chairman, I'm sorry, Delegate Ballard, Mr. Kingery's been compensated because he was compensated for being on the sexual offender list for, I think, the 6 or 7 years after his release. The argument was brought to me at one point, well, here's someone who's been in prison 12 years, got wrongfully in prison, got out, spent 3 years on the sexual offender registry before being taken off it as a result of exoneration. He or she should get 15 years worth of sexual offender. That isn't how I had envisioned. That isn't how I pitched the bill. I don't think that was the intent at the time. Someone wants to bring that bill, feel free. But that now, as to whether someone who's already been compensated but didn't get any time, any post-release time under the then existing statute, because there was no SOR in it, I think we'll see. There's some lawyers in the room. I think that person, may well be entitled to come back and say that there's a new law. I get to claim under the new law. And now that you mention it, I think I know that there's one before the General Assembly doing exactly that.
Thank you. All right. Anyone in the audience wishing to speak in favor of Delegate Sullivan's House Bill 1914? Anyone wishing to speak in opposition? All right, Delegate Sullivan, I think you anticipated this, I think, in your testimony. Delegate Keys-Gamarra.
You can finish.
Okay.
I just wanted to make a comment.
All right. So today at about 12:40 p.m., we got a fiscal impact statement for your bill. And so, of course, the folks upstairs would like to see it when we're done with it.
I'm not surprised.
I didn't think you would be, but so when it comes time for a motion, the appropriate motion would be to report and refer to appropriations. Delegate Keys-Gamarra.
Thank you, Mr. Chair. I just want to thank the patron for bringing this. I hope that this legislation will work as a deterrent to those that may be helping to bring false evidence or whatever else they do to try to secure a conviction where someone's liberty is at stake. And so I am one person on this committee, I'm sure I'm not the only one, that wants to do everything we can to discourage that. And so I appreciate you bringing it to try to make sure that folks can have a little bit more confidence in our legal system.
Well, thank you, Mr. Chair and Delegate Keys-Gamarra. I have a long speech, which I'll save the long one for the Appropriations Committee.
That was the short one.
We all know that there's no way to actually compensate these people, whether they've been wrongfully in prison for 1 year or for 45.
All right, we need to get Delegate Delaney back to criminal sub. So with that, I'd take a motion.
Yeah, motion to report it. Oh, sorry. Go ahead. Motion to report it.
Is there a second? Second? Moved and seconded? Second. All right. Anybody wishing to speak to the motion? No? All right. The clerk will open the roll. Members will cast their votes. Clerk, go ahead and don't mind. Delegate Sullivan votes for his own bill. So the clerk closed the roll. Bill reports 7-0. All right. Good luck in appropriations, I think somebody just said. All right, Delegate Delaney. You've got a little non-controversial bill.
No. I think it's pretty clean cut, actually.
All right, very good.
Thank you, Mr. Chair, and thank you, committee. So I have before you House Bill 1727. And I'll start by letting the committee know, I know we've heard a similar bill on this last year. We've spent a tremendous amount of time this summer working with stakeholders to come to what I think is going to be our best path forward. But I do want to remind the committee that an estimated 2.4% of U.S. women, which is around 82,000 Virginians, have become pregnant as the result of rape. Of these women, 1/3 have decided to keep the child. If a woman makes the choice in Virginia, however, state law leaves her vulnerable to a disturbing reality. At any time, her rapist can claim parental rights over her child, attempt to gain custody or visitation rights, or otherwise be involved in parental decisions. Unfortunately, in Virginia, a court can only terminate a parent's rights, even a rapist, when the child is in foster care, providing no legal process for a mother who is caring for her child to remove the rapist from their lives. A survivor of rape can try to pursue criminal proceeding against her rapist, a process that can take years. So while my bill last year, which was HB 765, created an avenue to terminate parental rights, I worked with stakeholders and addressed concerns that were raised, and now before you this year, HB 1727 would bring Virginia in line with 48 other states that provide some process to remove a rapist from someone's life. The bill explicitly acknowledges what other states agree. You don't have to claim to be a parent if you raped the other parent. You don't have a claim to be a parent if you raped the other parent. In fact, Virginia already recognizes that rapists cannot be parents. Courts, including the U.S. Supreme Court, have long recognized that biological parents who conceived a child through a sexual criminal offense do not obtain parental rights simply by the biological connection. Therefore, Virginia law should not allow for parental rights for a biological parent who conceived the child through sexual offense. This process can proceed in the same manner as other cases establishing parent and child relationships. In Virginia, mothers are already not required to put fathers' names on birth certificates or aid applications. This bill clarifies that at the point of birth, the rapist parent has no right to claim. The bill also acknowledges that an existing relationship with the child needs to be protected. If a claim is brought at that point, the bill follows existing statutes to ensure the child's best interests are considered. It is possible to achieve the goals of this legislation by addressing the problems before it begins, while also protecting for exceptions. By amending the existing code to address how a parent gets rights in the first place, we can prevent a rapist from having parental rights if the survivor parent should ever choose to have the baby. By further amending the code, we can ensure that a person of legitimate interest does not include someone who proven by clear and convincing evidence to have raped the parent. So today I ask that we give survivors an option as soon as the evidence of rape is available to them. Don't force them to rely on the criminal justice system. It is time for Virginia to open a pathway for survivors of sexual violence to ensure that they have a choice to not co-parent with the individual who raped them. So you'll have the opportunity to hear today from experts and survivors who have worked tirelessly to provide this relief to survivors. And from survivors like Jen, who is here to testify today about how this legislation would improve her life and her child's life. Thank you, Mr. Chair.
Thank you, Delegate Delaney. Does anybody on the subcommittee have questions for Delegate Delaney at this point? Delegate Lefwich.
Thank you, Mr. Chairman. When I read over this, I understand the conviction. Most things are heard by preponderance of the evidence, but this interjects a clear and convincing standard. And I'm not saying I object to that, but I'm just wondering where that clear and convincing standard works its way into the process when a civil matter would be by preponderance of the evidence. And if a conviction was involved, it would be by clear and convincing evidence.
So, Mr. Chair, I'd answer the delegate. We sat down with a variety of stakeholders, many of which you will testify today. And some of that conversation may come up in some of that testimony. And I'll answer from my perspective, but then I'd encourage the chair to hear the other testimony and more thoughts on that process might also come to light. But, working with stakeholders, trying to strike the right balance here, because we recognize that the current process for someone to have any remedy that even nearly resembles this requires a conviction, and that is simply not always an option, and it may also take place long after the child is born, and that would therefore force that parent to co-parent during that court process. And so, having a variety of conversations with a lot of stakeholders, this was the language that we reached to find most reasonable among those who were at the table.
Follow-up question, Mr. Chair.
Delegate Lefwich.
Perhaps for counsel, would the clear and convincing standard arise in the juvenile setting? Let's say there's been no civil case, and there's been no conviction. Would the juvenile judge then evaluate this parental status pursuant to clear and convincing evidence? Is that where that standard burden of proof would come in?
Mr. Chair, Delegate Lefwich, that's my understanding. The way that the bill is drafted is that there would be some sort of determination in the JDR court.
All right, thank you.
And I think what I heard Delegate Delaney say was that this is a compromise, that if we're up to her, she might actually go with the preponderance of the evidence, but some of the folks that we'll hear from that are probably in opposition think it should be only a reasonable doubt, criminal conviction, and this is sort of a middle ground.
Yeah.
So I understood it.
That's
Delegate,
where I was going.
Yep, Delegate Ballard.
Thank you, Mr. Chairman. Delegate Delaney, I'm just curious, during the kind of compromise or the work group, what was the thought process to exclude any statements made in this proceeding for use in a criminal prosecution? I mean, typically someone testifies, you're on the record, and you're on the wrong side of the V in a criminal prosecution, it could be used against you. So what was the thought process? Can you just kind of walk me through that, please?
Yeah, absolutely, Mr. Chair. I would answer Delegate Ballard with, again, kind of trying to strike that balance of fairness for all. And, I think that there had been some concerns raised about the application of this remedy. If there was knowledge that someone could then have that used against them in criminal court, they might be less likely to comply with this proceeding, knowing that, their counsel would likely advise them to not testify and to not participate in this hearing. So having that ability to have the consistent testimony used in the criminal case, the consistency of the testimony would be available, but the actual contents of this being used in the criminal court would alleviate any concern that saying anything in this civil matter could have ramifications that would affect their counsel to just shut the whole thing down and stall the process.
All right, Delegate Kilgore.
Yeah, one thing I'm noticing also is that, for a criminal case, a felony, there's no statute of limitations, but you have to be found guilty beyond a reasonable doubt. Here, we also do not have, here we switch it back to clear and convincing, but there's no, 15 years from now, here's what I'm thinking, that somebody could get caught in this situation, not, and it comes before the court, and then it's clear and convincing evidence. There's no timeline to go back and then all your evidence may be gone. That's just something to think about, because these are tough cases. They're tough when it's a criminal case, and it's going to be tough. These are going to be tough cases also. Just something to think about as you're going through this process. But I am concerned about the clear and convincing evidence standard, as others have said.
All right, Delegate Sullivan.
Thank you, Mr. Chair. On that question, and with the caveat that I don't, practice in JDR, never tried a parentage case. I'm looking at line 287. So this is 20-49.4. So maybe this is a question. I suppose this is a question for counsel, Mr. Chair.
Just ask it into the ether, and we'll see who has the answer.
I'll ask it into the ether. The bill doesn't make any amendments until the end of line 287 with the sentence that starts any statement. So that has to do with the admissibility issue. This looks to me like the existing code is that the standard of proof in an action to establish parentage is by clear and convincing evidence. So that's not new to this regime. Is that right, counsel?
Mr. Chair, Delegate Sullivan, that's correct. The first existing 20-49.4, the standard of proof in any action to establish parentage shall be by clear and convincing evidence.
Okay, thank you.
Got it. All right. With that, why don't we go ahead and hear from folks in the audience that wish to speak in favor. I think we have one person who's online as well. But let's start with the folks here in the room wishing to speak in favor of Delegate Delaney's bill. So please identify yourself and go ahead and begin your testimony. Since we have some folks lining up, I'm not going to put a time limit on anybody, but just be cognizant that if what you would like to say has been said by the person before you, there's no need to repeat it for emphasis necessarily. And just be mindful of the committee's time, and sometimes less is more. But go ahead.
Absolutely. Thank you. So I am here today to speak in support of House Bill 1727, legislation that addresses a grave injustice for survivors just like myself.
Your name?
My name is Jennifer, and I want to note that I have been advised by my legal team today not to be here and to speak today out of abundance of fear, not only for myself and for my other children that are not biologically related to my rapist. I'm here today to speak for survivors in the state of Virginia just like me, because I know when I speak, I am not alone. I want to paint a picture for you of what life is really like after you are raped and you conceive a child. And it all begins in a hospital ER with me walking in, not knowing where to go or barely able to speak with another person by my side. As they guided me back to the room was so packed with children. And I sat there for a few hours with tears streaming down my face. And they asked if the children could go in front of me because they were so swamped and underfunded. And I quietly shook my head yes. Another hour or so goes by, and they called my name. I walked by as they start to perform the examination, and I'll spare you the details of the examination because it lasted 6 hours. After the examination was done, I stared at the ceiling, feeling empty. I was only a fraction of a human being. Nearly 6 hours later, as I stared at myself naked in the mirror, I had no idea who I was looking at. And I can tell you that there is no woman on this planet that would sit through that and file for custody and choose life for their child after being raped and do all of this because it's labeled as a high conflict custody case. I'm nearly 8 years into this and co-parenting with my rapist. And I do it every single day, every minute, every second. And it is hell on earth. And luckily, I have a support system. Not everybody like me does. After my rape examination, it was nothing short of hell. I grappled with court appearances, threats, police, depression, losing my house, my job, and a resulting pregnancy. My life had been completely turned upside down, and despite the promises of protection, the protection of the law did not come, and I quickly educated myself because in the state of Virginia, there is no protection for somebody like me. I fell into this gray area, and once the child is born, the circle of control and abuse continues in the family court system as long as this bill does not pass. And without the passage of this bill, rapists are essentially choosing the mother of their children now. Imagine being forced to hand your child over to your rapist every other weekend. Imagine checking your phone constantly, looking over your shoulder, dreading the next message about visitation. Imagine explaining to your child, well, they have to spend time with someone who caused you and the rest of your family profound trauma. And this isn't a hypothetical scenario. This is reality for several people just like me. My new reality looks like this, and it's not living. This is not living. This is not a high conflict custody case. This is my everyday, and I cannot stress that enough. It is a slow, torturous death, not only for me, but for my child, who is now 8 years old. She just turned 8 in December. She has no idea, but she feels this deep, dark undertone, and she is asking a lot of questions. And imagine that conversation that I am going to have with her eventually. And I'm telling you, that day is quickly approaching. I am court-ordered to have parent coordination sessions with this individual, and how do you think that goes? My parent coordinator cries with me silently while he puts him in a breakout room because his hands are now legally tied. The other professionals in the court case tell me to get over it because I need to calm my nerves. The GAL on my case, her exact words while I testified in the custody case said, "Why aren't you texting him all the good things that are happening?" And my response was, "Why am I not texting my rapist? Please explain that to me. Would you feel comfortable texting your rapist? Would you feel comfortable sending your daughter home with the man that raped you?" And I got no response. It's far too often that these cases are labeled high custody cases. And like I said, I'm falling into a gray area, and we're being forgotten. I could go on and on about the things that I'm enduring every single day and the intergenerational trauma that I'm enduring. And it's not just me, it's not just my child, it's my other children that are not even biologically related to him. He's contacted my employers, I've lost jobs, I've lost homes. It doesn't even fall into landlord stable tenant law, but that's a whole other issue. Don't even get me started there. This is a tragedy happening in the state of Virginia, and it's not being addressed. The constant control, intimidation, and threats that I endure every single day, and it's court-ordered, and I'm gonna have to endure this for the rest of my life. And so are my children and my extended family. This is intergenerational trauma that I am forced to endure because I chose life. I chose life. And I'm now being punished for it. And I'm just here to tell you that victims often can't completely cut contact due to these custody co-parenting requirements. I can't stress enough that HB 1727 is so critical. It provides a pathway to protect both survivors and children from being forced into these dangerous situations. And like I said, I could go on and on for days. What I live like, what it's really like. I've already accepted the fact that this man will eventually kill me. He's openly made threats to me and my family and my child. And there is no protection. And I've made arrangements in the event and when he does. This is about protection. It's about preventing rapists from using the family court system as a weapon. It's about giving survivors the chance to heal and raise their children without being tethered to these people. It's about breaking that cycle of trauma before it begins. And ultimately, I just want to be able to teach my child and my other children that when they grow up, that love doesn't hurt, that safety isn't earned, and that their voice is one of the most powerful things that they own. Thank you.
Thank you.
Jen, thank you so much for sharing your story. Committee, I thank you for the opportunity to speak today in support of this bill. My name is Dr. Lucy Guarnera. I'm a licensed clinical psychologist and assistant professor of psychiatry and neurobehavioral sciences at the University of Virginia, although today I'm speaking in my private capacity and not as a representative of the university. For the past decade, I have researched what happens when women become pregnant from rape. I've reviewed the scientific literature, interviewed dozens of women about their experiences, survivors like Jen, and surveyed hundreds more. I want to briefly share 3 things that I've learned during my research. First, I've learned that most people do not think about this issue very often, and they don't want to think about it. Many people start off with disbelief that this happens at all, or that a rapist would ever want custody over his child. But the data tells a different story. My own research shows that out of women raising their children conceived in rape, 1/2 have the perpetrator threaten them with custody or parental rights, and fully 20% end up fighting their rapist in court for parental rights. Why does this happen? Well, the rapist can have many different goals: to harass or intimidate them, to retaliate against them, to coerce them into not reporting the rape to law enforcement, or to trap them into an ongoing relationship from which they cannot escape. Given that only around 3 out of 100 rape victims will ever see the perpetrator convicted, any law that requires a conviction to operate will fail to protect most survivors and their children. Second, through my public opinion research, I've learned that HB 1727's position is a popular one. Most people support policies that curtail a rapist's parental rights over a child conceived in rape, as long as the policy protects against false claims, which HB 1727 does. And finally, I've learned that the federal government has supported a civil procedure to curtail rapists' parental rights over children conceived in rape since 2015, and around half of states have followed suit. If a policy is supported by states as diverse as Maryland, Colorado, Florida, Michigan, Georgia, Iowa, Connecticut, Massachusetts, and Texas, I hope Virginia can also find a way to protect rape survivors and their children. We are fast becoming an outlier and falling behind the emerging national consensus on this issue. For all these reasons, I support this bill, and if there's anything I can clarify about scientific knowledge in this area, I'm happy to answer any questions the subcommittee may have. Thank you so much.
Thank you.
Good afternoon, Mr. Chairman and members of the committee. My name is Kevin Kissinger, and I am a law student in the University of Virginia Law's State and Local Government Policy Clinic. The views I express today are my own and are not representative of the university or the law school. The clinic has worked with Delegate Delaney on this issue since the fall of 2023, and I'm here today to ask that you vote for HB 1727 because it will promote safer and more stable livelihoods for children born from rape. HB 1727 responds to concerns expressed about its predecessor bill last year in 2 important ways. First, HB 1727 builds on the existing custody and support structure in Virginia law and does not create a separate cause of action. Second, unlike the previous version, this bill does not provide a process to terminate parental rights. Instead, this bill offers 2 essential protections for rape victims in this situation. On the one hand, it prevents rapists who have no relationship with the child from establishing parental rights at all. And on the other hand, if a relationship already exists, it gives victims a chance to change the custodial status of the rapist parent to a party without a legitimate interest. It's also worth remembering that because this bill is amending the child custody process, the best interests of the child will remain paramount for judges making these hard decisions. In short, this bill provides opportunities to survivors to prevent and remove co-parenting rights from their rapists, protects the best interests of the child born from rape, and prevents rapists from benefiting from their abhorrent behavior. For all these reasons, and those provided by others today, I ask that you support HB 1727. Thank you.
Thank you.
Last but not least. Good afternoon, committee. Delegate Simon, thank you for taking the time today to listen to our testimony, and especially to Jen for sharing her story. I'm Molly Montague. I'm the Director of State Legislative Affairs for the Rape, Abuse, and Incest National Network, better known as RAIN. We're the nation's largest anti-sexual violence organization, and we also run the National Sexual Assault Hotline, which I'd like to refer anybody to who may be needing it this afternoon. Allow me to paint a further picture of what Virginia is doing to survivors in a way that virtually no other state is permitting. A young woman is raped, and as the result of that violent crime, conceives a child. She chooses to keep that child, not realizing that in Virginia, doing so means she will have to interact with the man who raped her, expose her child to him, and risk both their safety. No sexual assault survivor should be controlled by the person who raped them. Rapists should not get to claim to be a parent. Allowing them to do so permits them to benefit from a criminal act. Virginia must stop forcing people like Jen to co-parent with their rapists. And Jen is not alone. I'd like to share briefly one other quote from another survivor. Being raped and going through all of that was tough. And deciding whether I wanted to keep my daughter or not, that was rough too. But I think the worst part is the court. And I had all the evidence. I have it. and it means nothing. It means nothing. Unfortunately, the trauma of the rape was only the beginning. I've spent the last 2 years going through something even more traumatizing. A month after my daughter was born, I was served with a lawsuit for paternity test and joint custody from my rapist. Every day since then, I have felt totally helpless. No one should have to stay connected to a rapist. I want to be the vivacious sales rep again instead of the shell of who I am now. I want my daughter to be safe. No one deserves to be essentially tied with their hands behind their back, gagged, and have to watch as the child they love goes to someone they know is dangerous." Unquote. These survivors need a process to remove the rapist from their lives and that of their child. They need you to protect their children and themselves. Virginia offers few alternatives to someone who has to see, speak to, and co-parent daily with their rapist. This bill tackles the problem before it begins, while also protecting the best interests of the child down the road. For people whose journey to parenthood started with their choices being ripped from them, this bill empowers them with an option. Without this bill, the Commonwealth is failing to protect parents and children from rapists. Thank you.
Thank you. And then, Delegate Delaney, I have a note that there's a Sandy Johnson online. Is she available to answer questions, or do we need her to testify, or both?
Ms. Johnson's available for technical questions if the committee has any.
Okay, let's go ahead and hear from the folks that are in opposition first, and then we can see if we need to ask any technical questions. So if those that are in the room that are seeking to speak in opposition to the bill, please come forward.
Mr. Chairman, Josh Hetzler on behalf of the Family Foundation. We're very sensitive to the issue at play here, but we are very concerned about the level of due process that parents would not be afforded under this. We think the higher criminal standard ought to be what should occur if you're to take something as fundamental as parental rights. I also want to mention that in terms of, there are a lot of different categories of rape as we understand, statutory rape being one of them. And so under this bill, as I understand, consenting teenagers, 13 and 14, including the male being the same age or being a year or two older, it would be automatically rape. And we don't think that father should automatically lose his parental rights because of that consensual act. So for those reasons, we would oppose. Thank you.
Mr. Chair. Sir, I'm sorry, I was distracted. You say we. Who are you testifying for?
The Family Foundation.
Mr. Chairman, Richard Garriott on behalf of the Virginia Family Law Coalition. I want to preface this by saying this came to our attention based on a request last year for the predecessor bill to do a study. As part of that study, we did work very, very hard with Delegate Delaney and the Center for Local and State Government at UVA, and tried very hard to come to a consensus. From the coalition's point of view, our real heartburn with this is the lack of a criminal conviction. We feel that there needs to be a criminal conviction. Rape is such a serious crime. I mean, it's been years since I did criminal law, but I remember representing a young man who was accused of rape, and they lowered it down to assault and battery, and I was concerned that he was going to go to prison for life. And he went to jail and got a fine for a couple of, and that was after a jury trial. That's the one thing. When you're accused of rape anywhere in America in a criminal matter, you have a right to a trial by jury. In the juvenile court system, there is no trial by jury. This now, and I feel the intent of this bill is to allow a victim with all the right reasons to try to limit access to an aggressor, but do it in a civil matter, potentially before or without any criminal involvement. So what's going to happen procedurally is mother or father files petitions for custody. It goes before the juvenile court. There's an initial return date. Someone brings an allegation of rape. And as the previous speaker spoke, if we're talking about statutory rape, the rapist could be either the mother or the father. So that allegation is now brought before the court. Under this, the court is now going to have to set a separate hearing solely on the paternity aspect and have a civil trial on whether or not a rape occurred. Now, under this bill, the idea is that nothing that's said in that proceeding can be admissible in the criminal proceeding. So what happens now? If there's a potential criminal proceeding, the alleged perpetrator can be compelled to testify, because you can be compelled to testify by the opposite party in a civil matter, can be cross-examined, all while the investigator for the Commonwealth's attorney, the police, detectives are sitting in the back of the courtroom and able to get discovery in a criminal matter that is now not allowed in the Commonwealth of Virginia, because we all know in America and in Virginia, you are presumed innocent until you're found guilty. So I have a real concern about whether or not this may be some constitutional implications as to whether or not it forces someone to give up their right against self-incrimination. Additionally, we're talking about the presumption, assuming that we have a situation here where there's been a paternity test, DNA test, we know that the person is the parent. Under Troxell v. Granville, the Supreme Court has said you've got a constitutional right to be a parent. Currently in Virginia, if the Commonwealth goes to terminate parental rights in a foster care case, that parent, both of those parents who are subject to termination of parental rights, when I did this work, it was called the death penalty for parents. They have right to court-appointed counsel. If we're now talking about fundamentally altering someone's potential constitutional rights, are they going to have right to court-appointed counsel? Do we now have a situation where this victim, who may not be able to afford counsel, has to come into court, has to try to appear pro se, and have the perpetrator have court-appointed counsel to defend them in this matter? Then after, whether or not it's found that there is, say that we have the trial, it is found that by clear and convincing evidence by the judge that there was a sexual assault or a rape. Well, now do we go to the next step, have to have a hearing on custody as to whether or not the victim allowed contact, what contact was allowed, and how and when did you establish a parental relationship? None of these things are defined. I mean, the coalition's concern is mainly a constitutional one. We think this is a well-intentioned bill. We think that if you are convicted in a court of law of raping someone, absolutely, you should not have any control over that child or over that woman. But we feel that there are implications to our justice system that are just as important that need to be protected. Thank you.
Thank you.
Mr. Chairman,
What?
I have a question.
Question for the
Correct.
witness. Okay, go ahead. Delegate Thomas.
I think we heard, thank you. Mr. Chairman, I guess we heard earlier that states as diverse as Florida and Colorado agree that this legislation has worked for them. I guess my question is, given the picture that you painted in opposition, can you comment on those other states? I mean, there are legions of people that are being disenfranchised from parenthood, or it sounds like it's working in those other states. So I guess I'm just trying to rectify the picture that you're presenting when this is certainly not a case of first impression among many states across America.
Mr. Chairman, Delegate Thomas, I can't speak to what the actual wording of those statutes are in those states. I know that in my experience with national, at least family law organizations dealing with divorce and custody, there are many laws on the books, including here in Virginia, that we operate under that clearly aren't working. So I don't know what's going on in those states. I know in our study group that we did on the original bill, I don't believe we looked into what was going on in other states, mainly what the impact we felt would be here in the Commonwealth.
Thank you, Mr. Chairman.
Delegate Thomas.
I do believe we have someone with a PhD in the crowd who might actually know what the other states are.
We're going to get to her. In just a
Okay,
second.
great.
Okay.
We'd love to hear from that speaker.
Okay, we will.
Thank you.
Good afternoon, Mr. Chair. Valerie LaRue from Virginia Poverty Law Center. As the committee may be aware, VPLC works on issues relating to domestic violence and sexual violence. And so we have put a lot of time and energy into the patrons bill from last year, as well as this year. We also served on the study committee that Delegate Hope convened around this legislation. And we certainly thank the patron for all her many hours of hard work trying to reach a compromise. We also acknowledge the pain of survivors in these situations, and we certainly don't want anything to add to that. We also acknowledge that this is a really thorny issue, and unfortunately, I don't think that this bill addresses the issue. So one of the things that we see in Virginia and across the country is that, and I think that's part of what we maybe heard today, is that when a woman raises the issue of some kind of violence against her in a custody matter, courts have a tendency to view that with a lot of skepticism. And for that reason, across the country, the statistics show that if a woman raises an issue of violence against her in a custody matter, she is less likely to get custody, not more likely. And so that's an unintended consequence that I would really be worried about in this bill. The previous speaker also raised the issue that either the mother or the father could be accused under this bill, and that concerns us as well. So there's a couple different code sections where that could take place. One would be the issue of the minors who are having sexual contact. If the girl was older, she could be the one who's accused of being a rapist. Another is there is a statute that impacts consensual relations between people who are related, and that statute is included in this bill. So it would, even if there were a consensual adult who were prohibited under the bill from having sexual relations, that could also come within the statute, and that could end up with the woman, as an unintended consequence, being accused of being the perpetrator. Another problem is that this bill treats the same behavior differently depending on one thing, and that is conception, which is a matter of chance. So as an example, if someone rapes a woman, or if someone has a consensual relationship or encounter, sexual encounter with a woman, and a child is conceived of that consensual encounter, immediately after that sexual encounter that was consensual, at which the child was conceived, that person then commits an act of sexual violence. Well, that person has violently, attacked this person, and yet that would not count in this situation. So we have the same behavior, sexual violence towards this person, and because certain kinds of sexual violence cannot result in conception, that would not count, even though the sexual encounter, and I'm happy to be more graphic than that, but I prefer not to be. I see a frown. So I'm talking about consensual intercourse and non-consensual acts of sodomy, for example. Another problem is the best interest of the child. So a child could not only would not be able to get child support if this bill went into effect, but they also wouldn't be able to inherit from the paternal line if this bill went into effect, because they would not be legally related to that person. So if that person won $1 million in the lottery and died, that child would not have access to that $1 million. Again, these may be, rare circumstances, but nonetheless, they could occur. They also wouldn't be able to occur from the male or from the line of the disenfranchised parent, whether it was their grandparents or anything. It would also impact sibling relationships. So in a context where a couple had children together, and then there was a sexual assault that resulted in another sibling being born as a result of that non-consensual sexual encounter, the relationship between that child and the father of all the children would not be established. That would make it really difficult for the sibling relationship there. So I really think that this is a really well-intentioned bill, but I think it opens up a can of worms that could not be resolved by this bill. I would really rather see us work on the custody statute and who is and who isn't a party of a legitimate interest for the purposes of custody, rather than this bill. So I appreciate the patrons' attempts here. I just don't think that it really would work. So thank you.
Thank you. One more.
Good afternoon, Mr. Chairman, members of the committee. I'm Beth Coyne. With the Office of Executive Secretary, Supreme Court of Virginia. The judges who review bills on when the legislature comes around has recommended a position of oppose yet, but the court has no official position standing here as I am today. But their recommendation of oppose centers on purely core implementation issues, many of which were already touched upon by the representative from the VBA, which basically comes back to a criminal offense, rape, incest, carnal knowledge, being proven in a civil context. So a criminal basically using a civil standard of clear and convincing instead of having to prove beyond a reasonable doubt, and the fact that that type of case would be held in juvenile and domestic relations district court, which is not set up for these kinds of cases between adults. So there'd be no court-appointed counsel, was already mentioned, and then, of course, who is the prosecuting the case on behalf of the person that was alleged to be raped. So at this point in time, it's court implementation process that the court is, that the judges had concerns with.
Thank you.
Thank you.
All right, and so we have, excuse me, an expert on deck, Ms. Sandy Johnson. Would you like to call on her?
Yes, Mr. Chair. Sandy Johnson is available online. I think to possibly respond to some of the statements that you just heard from opposition into a little more technical detail. I think there are some details in the bill that contradict some of the statements you might have just heard. But I think, also just to kind of have the committee consider, we spent the summer working with a lot of the folks in this room on this bill. And, I understand that this is, a delicate and difficult subject, but just to reemphasize that 48 other states are already doing something better than we have now. We've heard a tremendous amount of hypothetical things that could go wrong. And of course, as members of especially the courts committee, we have to very heavily consider those unintended consequences. But I think we have before us the very real consequence of our inaction, which was Jen's testimony, and so many like her, for which the hands of the court are tied, because Virginia cannot find a way to answer the question. If this is not how you would like it done, then please, by all means, tell me how you would like to see us fix it. So what we've brought for you today is, I think, the best answer to that compromise, still not satisfying everyone in the room, but reaching the point of, what else would you have us do? Happy to have had that conversation. We did spend the summer having it, and I think that the bill before you best addresses as many of the concerns that we heard raised to the best of our abilities, while still providing a remedy for survivors like Jen. But that said, Sandy Johnson is online for technical questions in response to some of the specifics about this bill that you may have just heard in opposition.
So, Delegates, did you have a question that you wanted to see if Sandy could answer?
I do. I guess my question is a two-part, Mr. Chairman. Question one, what other states have the most similar type of statute as being proposed here? And two, what has been the outcome of that statute in light of what we've heard from the opposition? Thank you, Mr. Chairman.
So, Ms. Johnson, if you would unmute, and we'd be happy to hear from you about that question and anything else that you heard you want to sort of react to.
Thank you, Mr. Chairman. Sandy Johnson with the Rape, Abuse, and Incest National Network. I would note that I have been an attorney for 20 years and have been a prosecutor for most of those years. I now work for RAIN. To answer that question in terms of what other states, I would defer to the earlier person who testified, who's done the extensive analysis of the other states who already have this in place. One of those that I would note is that, for example, in Michigan right now, we're actually working on a case where they have a similar process for what is involved right now. And I'll talk about that as an example that I think is helpful to show how this would work in reality, which I think is where people get caught up. So in Michigan, there is a victim who was 16 years old. She was sexually abused by her teacher. The prosecutors there brought 3 criminal charges against that teacher, all involving that sexual rape of that student. The defendant pled guilty. The defendant went to jail, and after 4 years sought custody and visitation of that child. The defendant came in and argued that because the 3 counts to which he pled guilty did not result in conception, but it was the other sexual activity that occurred that was in fact criminal, but didn't result in the conviction, that because of that, he could still have access to that child and still seek custody. In Michigan, they have where it doesn't require a conviction. It requires by proof, by clear and convincing evidence, that a sexual crime occurred and as a result of the conception that they could not have parental rights. There's an evidentiary hearing in front of the family law court. That judge made a determination that that crime or that the conception was a result of sexual conduct, and that case is now on appeal. In Virginia, that parent, that 16-year-old child who at the time conceived as a result of the sexual conduct, would not have been able to bring forward a claim. Instead, she would be forced to co-parent with the teacher who was in a position of special trust who raped her, and have to bring her child to the jail and the prison in order to effectuate visitation. So that's practically how it's speaking. It's working just fine in terms of family courts, and I'd like to just kind of address that. Number one, as opposed to the standard of proof. The United States Supreme Court has recognized there's a difference between a biological connection and parental rights. A biological connection does not equal parental rights, and I would agree with an earlier person who spoke that said Troxel stated, a United States Supreme Court, that if you're going to terminate parental rights, that it has to be by clear and convincing evidence. So the Supreme Court of the United States has indicated that the burden of proving something to remove parental rights is clear and convincing. This is not removing parental rights. This is not even acknowledging that there's a parental right to begin with because they're not a parent. They may be a biological connection to that child, but they're not a parent. So there's no constitutional issue at that point. We are using the highest level of a burden of proof in the family courts, in the juvenile courts, when it comes to parenting, which is why we chose the clear and convincing. In terms of the crimes themselves, I think there was comments about how if you have this process, and so what it would look like is if that person, that rape victim, were going to the hospital, they give birth. Right now, under Virginia law, the parent is not required to put the other parent onto the birth certificate if the conception was a result of sexual assault. So already Virginia recognizes that. That is something that is in place. If at some point the rapist parent were to try to assert parental rights, the victim would be able to come in and say, you raped me. The child was a result of conception. You don't get parental rights to even start with. And that is by clear and convincing evidence. I think there was an assertion by the courts that this would be unworkable, but how can it happen in court? And I would note that these judges are making these determinations every day already. When you're considering a parental relationship and removing custody or determining custody or visitation, that determination is already having to consider violent crimes that have been committed against the other parent. So the judges are already determining this. To say that we're concerned about it being a conviction, again, requiring it to be a conviction removes the ability for that victim to bring in the evidence to prove by clear and convincing evidence, again, the highest level of proof, that this was a result of sexual assaults. You're putting it into the hands of the survivor. So there's not any, because there's no, we're not talking about incarceration, the beyond a reasonable doubt is not applicable. The only thing that's applicable here is what the United States Supreme Court has said, which is clear and convincing. And just to go back to the original question, as a result of that, there have not been any constitutional claims that have been raised by these other states that have implemented this type of a scheme. There has not been anything that's gone up to the courts where they have specifically said that this is any type of a constitutional violation. In fact, when rapist parents have made the claim that they should have access, the courts have overwhelmingly held that if a child is conceived as a result of sexual assault, that parent doesn't even have parental rights. That biological connection does not equal parental rights.
Thank you very much, Ms. Johnson. We have, I think NCSL, I think Delegate Thomas thought was very specific. Is there somebody here who has can give us a sort of succinct answer about how this is working in other states? That the ones that you just briefly, if you wouldn't mind, tell us about if the parade of unintended consequences that we've heard suggested could happen if we're actually experiencing that in the states that have already adopted similar statutes.
Yes, so very briefly, in 2015, the federal government passed the Rape Survivor Child Custody Act. And so the federal government said, we want to incentivize states, of course, federalism, they can't force them, but we're going to incentivize you with grants to create a process, a civil process outside of the criminal process that does not require a conviction, a civil process whereby a person whose criminal sexual conduct results in the conception of a child, you can terminate their parental rights. For reasons that the delegate and many other people have talked about, we've chosen not to use the T word here for this bill. We're not doing termination, we're saying rights don't attach, but it's the same concept. It's saying we're gonna curtail parental rights. So the federal government says, we want this. This passes constitutional muster. We want you to do it. We want you to create this civil process. There were already a handful of states before that 2015 federal law that had a similar statutes, but since then it's exploded. So there's nearing about half of all states, we're over 20, nearing 25 of states that have created the same civil process that does not require a criminal conviction to terminate or otherwise curtail parental rights in the case of rape conception, where the individual's criminal sexual conduct resulted in the conception of the child. So in these handful of other states, and I name them, we have red states, we have blue states, we have all different kinds of states have passed these laws. They seem to be operating well. We don't have any comprehensive data on how they're functioning, but we do have the evidence of absence that, as Sandy noted, there have been no constitutional challenges. There not seems to be any sort of explosion of false claims or other kinds of abuse in the courts, certainly not something that has reached the level of attention within states or the nation. So it appears that these statutes are functioning within their parameters. They're doing what they're supposed to be doing, and Virginia could be one of them.
Thank you. All right, Delegate Sullivan, you have speaking to the bill or questions?
No, I have a question for somebody.
Okay.
Yeah, it sounds. I could just sense how much work has gone into this bill, and I've been in some of those long negotiating sessions. I'll start with you, Delegate Delaney. Two minors. Was there any discussion during these negotiations about whether or if so, how to treat that specific fact pattern any differently? Not statutory, an adult and a minor, but two 14-year-olds.
Thank you, Mr. Chair. I would answer the delegate that yes, we did definitely consider that. And I'm happy to have any of the other experts here that might like to kind of weigh in on this do so. But 14-year-olds can't consent to sex in Virginia. Mm-hmm. And so, that is just a fundamentally answered question, that if you are 14 in Virginia and someone is older than you by that degree, as the law lays out, that is not consensual. And I think the
16-year-olds.
the example that was given by Ms. Johnson, and I'd happy to have her come on and answer this as well, because I think she'll have a great answer. So after I'm done, I'll pass it to Sandy. But I think the fundamental issue that we're trying to get here is that you can't consent if you are under the age, if you're 14 or under in Virginia. Yeah, and the example that she gave of a teenager and that person coming back later. But I'll turn it to Ms. Johnson to.
Just so I think Doug, just real quick, I want to interrupt because I think the reason 14 becomes an issue is the scenario that happens is if there's got to be a 3-year age difference. So the only way you get two minors statutory rape is if the oldest is 17. That would make the other person 14.
Right. So, Mr. Chair, can I follow up?
Okay, go ahead, Delegate Sullivan.
With that understanding. Yeah. I asked the question wrong only because I really don't know what question to ask. I just, and I don't want to play hypothetical. So you're telling me that there was some thought given to it. It was decided that two teenagers, let's say 16-year-olds, whatever, two teenagers shouldn't be treated any differently than adults or an adult and a minor.
So, Mr. Chair, my understanding of Virginia law is if for it to meet the statutory definition, one of them is going to need to be 14, in which case we're talking about a young child by which consent cannot occur. 16-year-olds, if one of them claims that it's rape, then this standard would apply.
Thank you, Mr. Chair.
Thank you, Mr. Chairman. Just a couple comments. I was struck by the number of fact patterns and scenarios that some of the speakers gave that I hadn't even thought of, that in my mind puts this, Virginia's process of jurisprudence upside down. But as I was listening to some of this, I couldn't help but think that although the clear and convincing standard appears in the statute, that's for establishing paternity. This would say clear and convincing evidence could establish no relationship. And unless that's appealed, that becomes a fact that would be subject to res judicata. You could never, ever come back and say that didn't happen. There's new evidence. Whereas if you were actually convicted, there's the writ of actual innocence, and there are pardons that could allow you to come back in and say, okay, what caused me not to have a parental relationship now doesn't exist anymore. But in this scenario, you could never have an opportunity to say that. And I would have to agree that, there's some out there that would say, regardless of what the parents are going through, the child has a right to have a relationship with both biological parents. And there's a lot of body of law behind that. In a situation of rape, I don't care about that. I do believe should be a process, and I commend you for all your work you do in this space. There should be a process for someone who's been convicted of rape for that custodial parent not have to deal with their, abuser. But I just think that the right way to go about that is by having a conviction. That just puts this into a process that is consistent and can coexist with other areas and bodies and standards of law that we have in Virginia.
Mr. Chair, just to have the opportunity to respond to that, and if the first comment, I would absolutely love to defer to my expert regarding bringing it back up. But I think to comment on the conviction, when you look at sexual assault charges, convictions don't always happen, and there's a lot of reasons for that. And there's a lot of reasons why women who are raped never want to go through that process and are choosing, they want to be able to choose to not go through the criminal process for all the many reasons that survivors will very often choose to not pursue criminal charges, but will also want to choose to keep their baby. So it puts a lot of survivors in conflict between, I don't want to go to the police and file charges and have this go through the court and have my family see all this and have to testify. There's a lot of reasons why victims will choose to never pursue a conviction. There's a lot of victims who will pursue a conviction and not receive one. But they are also still faced in those early moments when they find out that they are pregnant from that rape to make a very quick decision of whether they want to carry on with that pregnancy or not. Not knowing the outcome of the conviction. That's going to happen after the baby's born. So, she finds out she's pregnant from the rape. The conviction's going to happen potentially years down the road, but she has to make that decision in that moment. And that's kind of the reality that we're faced with for many survivors, that there's no guarantee they will get the conviction, but they're going to make the decision about whether or not they want to carry that child far before a court date's ever set.
Thank you, Delegate Delaney. I would note, just to be clear, what we're talking about, the current code says that someone who's received a criminal conviction cannot establish parentage, and this is just allowing another process to get to the same status. So I will say we've heard some testimony about all the potential unintended consequences of denying someone parental status. Well, those all sort of apply when there's been a conviction as far as relationship with siblings and cousins and things like that. I think we should sort of, if we can focus ourselves here on what the issue is, I think Delegate Leftwich has sort of said what his piece about it is. He just feels like that should always be the standard and that there's problems with the lower standard. I've heard that this is in place in a lot of other states. And I guess the other thing is, just as a sort of commentary on this a little bit, the whole process is, I can always come up with a list of 25 reasons why we shouldn't do anything. But I think what Delegate Delaney is saying is, what are the alternatives, other than the status quo? It's easy to sort of pick things apart, but it's a lot harder to build something up. And so I know you've done a lot of work on this. I know that it's going to be problematic for a lot of folks, and we'll see how the chips fall here. But unless there's any other testimony, I think we are.
Move to report.
Second. Been moved and seconded that the bill report. Clerk will open the roll. The clerk will close the roll. Bill reports by a vote of 5-2.
Thank you, Mr. Chair. Thank you, committee. And I told you it would be fast.
All right, thank you. All right, so we got one more bill, which is mine. I'm going to hand the gavel over to Delegate Sullivan. We've got a substitute, so I would like to, since I'm on the committee, I'm going to move by adoption of a substitute.
So moved.
All in favor? Aye. Any opposed? We got the substitutes before us.
Okay, so this is a bill to clean up one aspect of the e-notary bill that we
I don't
passed.
blame you all for leaving, but try to be quiet.
This is the e-notary bill that we passed last year. The way it was written last year, some clerks, some places thought that it meant we couldn't recognize out-of-state e-notaries. This bill remedies that and says that by changing the definition of notarial act and says that, yes, you have to recognize out-of-state e-notaries. So if a document was notarized in another state using their e-notary process, we'll give full faith and credit to that e-notary process, and the document has to be recorded in Virginia.
So this is a fix from last year?
It's a fix from last year.
Any discussion by members of the committee?
Move to report.
Second.
Motion to report properly second. Any further discussion? Hearing none. We're moving to report the substitute, aren't we, Delegate Ballard?
Yes, thank you.
That was your second, wasn't it? Yeah, okay. All in favor, please, Madam Clerk, would you please open the roll?
Is that it?
Go ahead. All right, and that, I know we had two people. Thank you guys for coming and being willing to testify for that last bill. All right, with that, the committee is complete and the committee will rise. The work of the committee is complete.